Hello, I'm David Tate. I'm a California attorney. I'm also an inactive CPA. This is a brief discussion about a new California trust litigation case. The case is Zahnleuter versus Mueller out of the California Court of Appeal, 3rd District. I also write 2 blogs. One is for trust, probate, will, elder abuse, power of attorney, and real estate litigation. And one is for business, D&O, and related litigation and governance. Both blogs also discuss mediation. You can find the addresses for both blogs on the slide. The issue in Zahnleuter was whether or not the trustee could pay his attorney's fees out of the trust assets. Payment of trustee attorney's fees can be a complicated and unsettled area of law. In Zahnleuter, the issue involved the contest of 2 trust amendments. The trustee was not a beneficiary, which was important, but he did take a position that one of the trust amendments was valid over the other trust amendment. Thus, he did not merely sit back and allow the disputants to litigate the matters, but he became actively involved. Although it does not appear important to the decision in Zahnleuter, it does not appear that the trustee first filed a petition for instructions as to whether or not he could become actively involved in the litigation. As is often the case in trust and probate litigation, there were also additional factual issues. The court found it important, perhaps critical, that the amendment wording did not specifically allow the trustee to defend the amendment against contests. The court ultimately determined that the trustee could not pay his attorney's fees out of the trust assets. He had already done so. There was a petition for surcharge, and he had to pay those fees back. The trustee's attorney's fees were significant, $200,000. The court reasoned that the trustee could not pay his attorney's fees out of the trust assets because he was not merely defending the trust, but was in effect taking a position that would favor one amendment and those beneficiaries over another amendment and those beneficiaries. You can find additional information about the case on the slide. Attorney's fees can be a complicated and unsettled and factually specific area of trust and probate law. You do need to retain your own attorney to advise you about your case and your situation. Zahnleuter is not the only or the last word on this subject. And in fact, I believe that some of the reasoning in Zahnleuter might be open to interpretation, debate, or dispute. I'm David Tate. I'm a California attorney. My practice involves litigation, mediator services, D&O, governance, and other areas. I have 2 blogs, and you can find the blog addresses on the slide. I hope you found this helpful. Please pass this information on to other people who would find it interesting. That's all for now. Thanks for listening.